Attorney Better has a number item as well.
Mr. Better.
Thank you, Judge.
Honestly, go fuck yourself, sir. You don't say that, okay? You don't lose a trial where a jury acquits someone and finds them overwhelmingly not guilty and say, I gave my sincere obligation to look into this, and I'm telling you all I saw when she's guilty. Again, respectfully, go fuck yourself.
Swear again like that. That was, no, I mean, whatever. That was, I shouldn't have done that.
A few moments later.
You, as a prosecutor, have got to be out of your fucking mind.
Nose.
Dude, Jimmy, look at those ears.
The ears don't bother me as much.
No, I don't trust a man. I don't trust a man with a lobe like that. No,
really,
not a fucking chance.
The mouth is butthole to me.
Very thin, paper thin.
The nose.
Oh, the nose.
The brows.
Well, listen, I will tell you though, I kind of like a fucked up nose on a guy.
Like a big old honker. I like a big nose.
Old nose. Give me that beak, bitch. You know?
Yeah.
Like, I'm into it.
Come over here. Cluck, cluck.
Yeah.
I see some chickens that went moving on up in my biz, cluck, cluck, running. You gotta be with the kids, the kids, the kids, the kids, the kids, kids.
And I go, oop, clutch, clench, kegel. We did it all. And I go, oh, and what happened? And they go, well, we just got 4,000 plus pages, bitch. And I said, stop it. Show me it. Take me to Unimpound Town immediately, if not sooner. So what happens?
The bitch is here.
Why are you at a football game? Are you a Fonz correspondent?
Well, no, because it's only for men over 30. Okay? Have a great night, boys. Fuck off.
It's been 1 week since you looked at me.
Hey, Blues Clues, motherfucker.
Oh. Hello, loveys. How are we? We are back together again, and it is September 22nd, 2025. What a day. What a Monday we have had. And I had a day at work. Okay. It's been a day. It's always quite chaotic on Mondays in my neck of the woods. But I needed to talk to you. I needed to talk to you. Why? Because we did some civil hearing for one Ms. Karen Reed. And it was more than I thought we were going to get today. Right, loveys? Like, it felt like a lot of information was put out. And let me tell you this, okay? At my house, we talk about everything. And we talk all the shit. But we're also like fact-based. All right. So we might have felt a lot of feelings today about like, oh, I'm sorry. Who in the fuck are you to say that, good sir? But like legally, I've got all the receipts. I've got cases that we're going to go over, that like the Semino case that kept being brought up, because I was like, what in this shit is that? I don't know the Semino case. So we'll have a reference point together. And we're going to see a new sheriff in town, if you ask me. And I don't know what he's going to be nicknamed, but my chat will absolutely put it together, because you're the best to ever do it on the World Wide Web. I was thinking like Accent Daddy. I don't know where he's from, but I like it. And we're going to meet him together. Are you ready? Oh, Jeff K says the hearing today was fire. Was it not? Was it not spicy? A Monday spicy tuna roll that I didn't see coming hit me like a ton of bricks. I said, oh, we're doing this. I clutched, I clenched, I kegeled. Put on a pair of pearls, babe, because we're ready to fucking go. And at 8 o'clock, I'm going to bid you adieu. Why? Because you have Mr. Betterow. Mr. Betterow has answered a call, so we're going to get rocking and rolling right now. On your mark, get set, play the tape. All right. Let's do a meet and greet. Hi, Mrs. and Mr. Reed. Oh. Are we not talking? You hear me? Is it South Africa? South Africa, daddy. No, we can't. That's weird. African accent, daddy? No. Legal accent, daddy. I don't know, but something is going to happen with him because I'm into it. Oh, hi, Jeff Machado. Hi, Erin. Hi, friend. Hi, Paul. Hi, Peggy. Hi, Boston Brandy. Who else? Okay, that's weird. Stop with the camera. Come on, guys. But also, reminder, it wasn't illegal. I didn't need a code. It was on Court TV. Cool. Cool. Oh, hi, Jess. Hi, Ted Damon, my guy. My former best friend from out of town. Hi, Cal. Okay. I want the judge to say, introduce everyone.
Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe et alia versus C&C Hospitality, LLC, DBA, CF McCarthy et alia. Case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well. Thank you.
Love it.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
The Dillers.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs. Good afternoon. Good afternoon.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Hi, again.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant, Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Oh, and I'm sorry. Oh, I'm sorry. Hello. These are our interns. They're still here. Hey, interns. Mr. Oh gosh, was it W? What was his name? I loved him. Mr. Wick? No, he's not Mr. Wick, not Sean Wick. Mr. Walk. Yes. Kelly. Mr. Walk is there. Oh.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, you say the waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Clint Gary also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Lincoln Rose on behalf of the defendant, CF McCarthy.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case
the event for this afternoon. Oh,
spring. The first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand. Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for.
Yeah, so there's always going to be, what do we have? Discovery issues.
In this case,
we hear it.
What we'd like to ask the court's indulgence for is we have.
Listen to this man, our South African king, part of the Justice League. I'm into it. Okay. He speaks. I listen. I go, hi. Didn't expect that. But now I like everything that you say. And I usually like everything that Karen's counsel says, but this specifically hit me in a good spot.
A proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should be in this case.
Right.
They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for order of extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider those depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, then.
Your Honor, a similar vote as to waterfall. We'll put efficient touches on our discovery responses. The last leg of it is just communications from employees.
Okay, babes. So what they're doing here is they're just asking CF McCarthy's, they're asking the waterfall. They're like, hey, babes, where are you at? And they're like, we're putting our finishing touches on. We're getting our shit together. We're going to be submitting. I love it. It's everything.
Proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took place.
It is, though. It's the plaintiffs. Well, just hear me out for a second. And when you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defense have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively.
And he shall be, from this point forward, civil daddy.
Bring
civil accent daddy. I can't help it. I want to have accent in there.
In 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both a procedure as well as the substance. And
Right.
we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case, and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for you, Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this...
I love that the judge is like, yeah. So anyway, I love that you guys are presenting this to me today. However, I'm just looking for a trial date. And then when the plaintiffs get up and start talking their ass about 30 minutes in, we will all need to look each other in the eyes, hold each other's hands for potential emotional support, and absolutely call on the names of Tiny Mary and Tiny Jesus in the boom to prevent us from dropping F-bombs, which we may do anyway, even though it's a mid-evening stream.
This case is. I take exception to the defendant's notion that this is not just a court action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct? There's 5 for the plaintiff and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order.
Civil levies. Okay, so there is not a speedy anything anywhere near it. 2027 is what we will be looking at. However, the discovery that will open up in this case will make the criminal trials of 1.0 and 2.0 look like kid shit.
As in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could. The clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now. So I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest, maybe a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial.
That's an interesting face of Paul, right? Like a smirk I did not expect. What are you smirking at? Peggy found his powder blue pullover, his little shirt today, and a little mommy and me-ish, but he made a choice to, like, I don't know if I'd be grinning right about now. Peggy, appropriately pissed off, on brand, and makes sense because she's angry still and understandably.
Economy without prejudicing the plaintiff. Discovery is already ongoing. But to have two depositions, for example, of
He
parties in two
does not
separate
want to be
cases,
there.
where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide ranging as they've just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or
Everything gets reserved right here. Okay, Levy. So now let's get to 33 minutes in, because this is when I teleported to a different dimension, and there is a lot to unpack. So let's go.
Or close enough in proximity to be able to advance.
Nope, just kidding.
If you review that case, I'll give this case site, 385 Mass 323. It's a 1982 case. It would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Wrongful death and emotional infliction of negligent infliction of emotional distress, the NIED claims. So they're overlapping, but they're not really, Loveys, because it's two different and two separate kind of claims within that action that is being taken in civil suits. Make it make sense. Peter Tragos, the lawyer you know, has broken this down because he is a civil lawyer most of the time. He does do criminal defense, I believe, still, but he's 100% in his bag in the civil litigation. And he had explained it to me or not to me. He didn't call me and say, Kim, wanted to tell you this. But there is specific hurdles in which need to be met in order for a plaintiff to not only get the 51% that it's more likely or not, but for the NIED claims, you have to prove, and it is a small window. It's a very thin line that you are walking upon, because everybody who has ever lost a loved one would be able to file a negligent infliction of emotional distress claim because we're grieving. And that is why, for example, if you are walking with your spouse on the street and your spouse is struck by a vehicle and you are there, he's holding your hand and he gets struck by a vehicle and he is unfortunately, God forbid, unalived, okay? You are seeing that. That is something that would be so extraordinary that it would make sense for that to be awarded to you, because it's just so egregious and it's so extraordinary for you to have to witness. Now, if you come upon somebody that you found unalived in a very short period of time, then that is a reason that could make sense. But in this specific case, if you look at the facts of the case, no one found Officer John O'Keefe other than Kerry Roberts, Jennifer McCabe, and Karen Reed at the scene at 34 Fairview. It was not the O'Keefe family, and unfortunately, we grieve for them, and we understand that they are 100% still in the period of loss and in the processing period of losing Officer John O'Keefe. They've had to deal with 2 trials as well. And they, I believe, were sold a bill of goods by the Commonwealth of Massachusetts and by the Norfolk DA's office that was intentionally misleading to them. And they've suffered through that. And I believe that they have suffered through that. But their pain and suffering does not come from Karen Reed or from C.F. McCarthy's or from the Waterfall Bar and Grill.
Thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss? No. Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iagino and others that deal with this issue. So,
Piney Woods, thank you. She is a lawyer. Says these types of claims are often called Dillon claims from the case, the seminal case out of California. Thank you, Piney Woods, Law and Crime.
With that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the 2 corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor.
Okay, and hear that and hear it well, loveys. It is assuming that all facts are true, and that's the judge's job. He has to rule in that way based on how our judicial system works. So you're going to hear some shit that you're like, no, that was actually, sorry, Ellen, that's not the truth. But the facts that he is putting before the court are what they are going to be basing the decisions made in moving forward.
Does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss, the lowest standard, the Brum case. Plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one.
And likely, loveys, they are going to be moving forward. They're, in my opinion, or for what I have heard from Peter previously on this, and from the motion to dismiss that was filed by the defense, I believe that there is enough for them to move forward, but I do not believe in my heart of hearts that there would be a jury that would ever find even 51% or any sort of responsibility on Karen Reed or C.F. McCarthy's or Waterfall. And it's devastating. I'm devastated that Karen's going to have to sit through more years of this. I'm devastated that the O'Keefe family are going to have to sit through additional years of this. And I fear, truthfully, what may come out in depositions may be devastating to families and to communities that if you thought damage was done in Canton previously, what could come out in these depositions could be generationally devastating. Do you know what I'm saying? Are you picking up what I'm putting down?
There are 3 arguments that my brothers have put forward in this case. We oppose all 3 of them as follows. Number 1, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number 2, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright-line test for such cases. Number 3, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 20.
I have a problem with it. Oh, I hate it. Okay. I can't stand it. I cannot stand it. I understand that that was a nickname for Officer John O'Keefe. I get that that is something that is referred to by his niece and nephew. And I know that it comes from a good place, but it feels so informal and it feels so disrespectful in a court of law, in my opinion, that I don't like it. And I don't know why it just triggers something in me that I'm like, no, why are you calling him that? Because I'm sorry, sir, he doesn't have a voice and you sure as shit are not speaking for him. Okay. If it was his niece or nephew that wanted to say that on a stand, absolutely all day. But you using that informal term is hitting my spirit incorrectly.
2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold.
Oh, I'm sorry. Oh, and this is the moment that I lose my shit. Okay. And I go, oh, I have to remember, where are we? We're in civil court. Calm down, Kim. Okay. I go, who the fuck? What? Karen drives drunk. She strikes JJ and leaves him in the snow. I go, oh, we're doing this again. Oh, fuck my life. Like, we're trauma triggered. And it feels insane that they're able to go down this route, and it's par for the course. Okay. If we haven't watched criminal trials that have gone into civil suits, this is part of the shits, Lovey. We are all learning. We are all learning that this is how it goes, but it is so, it's just disturbing when you think to yourself, okay, well, Karen sat through 2 trials. The first trial, she was definitely acquitted of a second-degree unaliving of Officer John O'Keefe, as well as leaving the scene of the vehicle. Leaving the scene of the accident. Then there was a hung jury on the manslaughter. In trial 2, she is acquitted of all charges except for an OUI and whatever. Okay, but that is the only charge that is ever going to have a criminal saying on, or any kind of meaning on, Karen's record. And yet you're up here again, putting her through the ringer again. And I feel like it's attacking for no reason other than a monetary reward, or other than to say, like, why can't you say allegedly? Why can't you say, but he says that this is the facts of the case, and that feels just fucked on many levels, and he's going to keep it going.
And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost two parents. After provoking this chaos in the middle of the night.
Oh, well, Karen's face says it all. Geez, Kat. Look at Kat. She's like, not today, Satan. Like, I get it. I get it. And there is none of us, none of our loveys, and no one, I believe, does not have the utmost sympathy, and our hearts go out to Officer John O'Keefe's niece and nephew. The unimaginable loss of your two parents 2 months apart from each other, then your uncle, becomes your parent, and then his girlfriend, who becomes your maternal figure. You lose her as well after he is tragically taken on January 29th, 2022. You did not deserve any of it. None of this. No child should ever have to bear the grief and sadness that these two kids have. And my heart breaks for them. But now you're going to say that by Karen asking for Jennifer McCabe's phone number and freaking out because John didn't come home. And yes, she is absolutely going through what the fuck happened. And if you are asking a question, you can now be civilly responsible, or your claims are that this is where the plot started. Fuck off.
Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow. 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead.
Yep.
And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable.
Wow. That is a lot. That is a lot to take in, and that is a lot to process. This is a lot to unpack, babes. So he's alleging that Karen is plotting, potentially one of the worst cover-ups, if she had done it, the worst job that has ever been done. When she allegedly asked, could I have done this? Maybe you wouldn't do that. Maybe you wouldn't go back to the scene. I like everybody to just maybe take a step back for a second and say, either she's the smartest, you people make her out to be the devil because she's so smart and she knows everything, or she is the biggest fucking moron that ever lived. Gonna need you to pick a lane, okay? So she's plotting, she's planning, and she's doing this all and to this vulnerable family. And it was all in her plan. Instead of that Aiden, the turtle boy, gets a hold of the case, and he is like, something isn't right here. And without him, you would have tried to railroad her, and God forbid, if it hadn't got the attention that it had, the outcome, I believe, still would have been the same, because Karen Reed did not strike Officer John O'Keefe with her vehicle. But without the spotlight and without the community and eyes looking to say, holy shit, this isn't right. Do I think that it could have potentially at least been another hung jury? Maybe. But eventually, Karen would have had an acquittal on her charges in the death of Officer John O'Keefe criminally because she didn't do it. Period.
Grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief.
Oh, I'm sorry. Cop's daughter, Cosgrove quit? What do you mean he quit? What do you mean? Tell me everything. Wow.
And it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute.
Okay, I'm
We
going to get
reject
to you guys.
that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages, the lost value of JJ being in his next of kin's life. And in that case,
Breaking news, loveys. Aiden posted 5 minutes ago, Robert Cosgrove, Special Prosecutor Robert Cosgrove, officially resigned today from his role as special prosecutor in the Lindsay Catani indictments after she sued Cosgrove and Brian Tully at the urging of Grant Smith Ellis. Special Prosecutor Robert Novak also resigned after collecting $20,000 from taxpayers. Ken Mello was booted off the case 2 weeks ago, which we knew that. Michael Morrissey is unable to appoint someone new since she's also suing him. Without the towel completely sabotaging this case, none of this would be possible. It is perhaps one of the greatest legal gifts in history. One by one, all of these charges are going away. Oh my God. Loveys, I just wanted to say to you really quickly, on your mark, get set. This might be dismissed on Wednesday. After Mr. Bettero's mega motion, I want you all to prepare. And if you can get our asses down to court on Wednesday, this may be it. This may be the final nail in the coffin. And I'm going to tell you this. I watched Lindsay's video, and the one thing that stood out to me, I didn't care about the rest of it, but the one thing that stood out to me was I've been advised that these charges will be dropped. Or I've been advised that these will not be going forward. And I believe that she was. And the pivot that she's trying to make, I don't know how that's going to end up, but I think we're in for fireworks on Wednesday.
Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings...
So rude. First and foremost, it's the Cimino case. And sorry, guys, we're just going to get back to this. And he's like, oh, yeah, the father brought charges against the drunk and the bars. Rude. But we looked up the Cimino case. Why? Because facts matter journalism. And what did we find out? So the complaint was originally brought. This was on January 1976, not 1776, Kim. Richard L. Mott was operating his motor vehicle and caused the death of the plaintiff's son, John Cimino. Mott allegedly became greatly intoxicated while a patron at the defendant tavern keeper, the Milford Keg Incorporated. The plaintiff, Joseph A. Cimino, individually and in his capacity as administrator of the estate of his deceased son, John Cimino, brought this action against the defendant. The complaint was originally brought to the 3rd District of Southern Worcester on August 24th, 1976, and alleged 2 counts against the defendant, one for wrongful death of the son and the other for the decedent's conscious pain and suffering. Hence why we're talking about the wrongful death suit as well as the negligent infliction of emotional distress, the NIED claim, right, babe? We're going to law school, JK. And the action was removed to the Superior Court on the defendant's motion on September 21st, 1976. I'm going to keep fucking that up. The plaintiff's motion to amend his complaint, adding the count of negligent infliction of emotional distress on the plaintiff, was allowed on April 3rd of 79, and the case was tried. And the jury found all 3 guilty, right? So, they found for the plaintiff in all 3. And that's why this plaintiff is using it, that you can use both together. Okay, continue.
2 separate causes of action. One for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of.
Yeah, Morrissey can't appoint anyone new, so there is no one. Let's repeat that, loveys. We're going back to Aiden's new tweet about Cosgrove. Morrissey can't appoint anyone. So this has nowhere to go except bye-bye.
Action for emotional distress. Emotional distress as a concept has evolved in the Commonwealth is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brother.
Thank you so much, Lovey. I love that, Katz Randall. I'm going with the Magnificent 7 for Karen's civil team. AJ is Charles Bronson, Damon Siegelson, the Yule Briner, LOL, of the 1960s original.
Others just argued here in this court, and I see no reason why this court should overturn the good standing law that exists under the.
I can't, Lovey. I can't call Mr. Betterow. He's at supper right now. I can text him though, and he's going on with Mikey in 20 minutes. So if you can ask, then. If you can ask in his chat, I would. Ready? On your mark, get set. I'm sending a text.
We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress.
Oh, hi, AJ. Oh How you doing?
For that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead.
Okay, so I've got to push back, Loveys. Oh, wait, how did that happen? What did I do? Okay, I have to push back on that just a little bit, because if you go back to trial 2, we know that Dr. Laposada, and there's a reason for everything. Remember that. She specifically testified that Officer John O'Keefe likely succumbed to his injuries very quickly after he sustained them. She said, nope, there wasn't a chance that he was alive. Nope, that didn't happen. Nope, he should have been pronounced, technically, in her opinion, at the scene. Okay? And he never had a heart rhythm, and they never got a rhythm on Officer John O'Keefe. His core body temp was 80 degrees. If Officer John O'Keefe passed away within minutes, okay? After whatever happened to him, then it would not be that the family, meaning the O'Keefes, saw him just, quote, minutes after he was pronounced, because he would have, in theory, have not been transferred and transported to Good Samaritan, or he would have been considered or ruled in the field DOA. Okay? So this is huge. And there was a reason that we had Dr. Laposada in the second trial. There was also, she pushed back against hypothermia, because the findings that Dr. Laposada said she did not see in the pancreas and the stomach of Officer John O'Keefe that she would have wanted to see for a diagnosis, and in combination with the blunt force trauma to his right occiput, with the hypothermia, which was the finding of medical examiner Irene Scorti-Bello. She did not find that. She said blunt force trauma only, and that minutes after occurring, that the brain swelling and the pathophysiological reaction of Officer John O'Keefe's body would have rendered him unconscious, him been unable to have, meaningful action and movement, and that when his brainstem herniated, that would have been a time of death for Officer John O'Keefe. Therefore, ergo, the pain and suffering of seeing your family member within that window that is very specific in civil cases, right? The example of you're holding your husband's hand and he is unalived right in front of you, negligent infliction of emotional distress. You being at a hospital after somebody had been passed away for several hours does not meet that criteria. The reason that the O'Keefe family are using this argument, because they are saying that Officer John O'Keefe was alive at that time, and minutes later, they were told to go into the back room and given an opportunity to see him, therefore meeting that criteria.
It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone, does not experience the injury, and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel.
Huge. Now he's bringing this up, and I hope that that did explain it in the way that I've been able to understand it, Loveys. There is expected anguish for anyone. Any one of us who have lost loved ones have experienced anguish, grief. These are all things that are part of losing people that we love, period. And our hearts can go out, and you need to heal from that. But there needs to be, for the emotional distress claim, like a diagnosis, like an actual ICD-10 code that you are suffering from this emotional distress, whether you have anxiety, that you have a new diagnosis of anxiety. Not me. I couldn't claim it. Why? I've been anxious since I was born. But a new diagnosis. Do you have a somatoform issue? Have you broken out in a rash, a rash of unknown origin that will not go away? These are all things that you need to look into and be able to prove that stem directly from this infliction of emotional distress. And that is case law. Like, you have to have that. So I'm wondering what is going to be and what they are going to say they have done for their trauma, and what kind of counseling and what kind of psychotherapy that you have underwent that provided these diagnoses. And also, that shit is all going to come out in the wash. So now all your private shit is no longer private in civil court. Do you hear me?
From the death of a loved one. I want to talk briefly about Kaylee and her NIED claim. To suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury, contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I would refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim.
Right.
So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody.
But the proximity isn't there, right? I personally feel, Loveys, that Kaylee, if anyone had a case, it would be Kaylee. Everyone else, no offense, I do not believe. But Kaylee, but she doesn't have it just for the proximity and the knowledge of it. And by Karen's talking to her that morning and being frantic and panicked and asking for a phone number does not equate that was her perceiving or having her sensory perception of the events that unfolded about 2 hours later. Like, and you also have to remember, Loveys, that Karen is the only person that from the scene was transported to Good Samaritan Hospital for a Section 12. She dropped her basket. Karen Reed suffered emotional distress. Karen. And I'm not saying that, like, I'm not saying that makes her any different in the situation, only saying that how she was behaving and her having an anxiety about where he was when he did not come home does not equate emotional distress in my brain or how the civil law code is defined in Massachusetts.
Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to.
Again, I do not find it to be the outrageous and extreme behavior. I do not think it meets that threshold by any means, especially when you are suffering from a mental health crisis and when you are undergoing the exact same trauma that everyone else is experiencing. And unfortunately, you were the one who found him.
Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of
A hand
the
shot
plaintiff
of Karen,
to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we posed to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead.
Okay, now, but in that same breath, Loveys, is it hours before he is found or hours after Karen allegedly, as they're going to portray, committed the act? Because again, the time matters. The small window of relevancy matters. So are you saying that it's hours after Officer John O'Keefe was struck that she alerts Kaylee that he might have been hit by a plow, and she looks for the phone number of Jennifer McCabe? Or are you saying that this is a prequel to her going out and finding his body that she goes back to and then tries to save when she is the one performing CPR on him? Which fucking one is it?
Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos?
Okay, what Turtle Boy said is not Karen Reed stating that. So I don't remember specifically Aiden saying that, but Karen Reed is now held responsible for the words of other people. Okay.
That got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before. To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret?
Yes, sir. Discovery will produce receipts of the illegal conduct, of whom I do not believe that you are prepared for. How about that? How's that grab your ass, guy?
And John have now buried 2 children. Paul has buried all his siblings.
Oh,
the defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases they cite. The Pillay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience.
Shut the fuck up. You shut the actual fuck up. What? Go on.
With editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID.
Well, I'm sorry. I'm sorry, Ellen. That's not right either. Because she hasn't gone on Turtle Boy. Okay. Did you mean to say The Glarer? Because she did go on with Will twice. Okay. Get your facts right. But if you're going to name all the things, babe. She hasn't done anything except Howie and who else? Oh, and she talked to Billy for a minute. But no, this was all after trial 1 and before trial 1. And yes, pardon Karen for getting out in front of a life sentence that was hanging over her head, potentially. When you are innocent, sometimes people want to talk about it. And all there was never anything about the O'Keefe family that she was talking about. What she was saying was, hi, I didn't do this. And I believe that somebody in the house, or I believe that something else happened. But I did not strike Officer John O'Keefe with my vehicle. And let's be perfectly fucking clear, pal. I don't think any of the goddamn times that Karen talked helped her, okay? They weren't used as like, oh, God, here's our sympathy card. It was always critiqued and pulled apart and read for filth. Everything that she said was fucking used against her and in a court of law. Do what you will. Do your worst because she's already lived through it.
Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third.
Found her not guilty, which is different, by the way, than innocent. You little son of a Gumby. I'm going to watch my mouth, Zach. Okay, but Tiny Mary and Tiny Jesus understand. Rude.
Of those arguments, they should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not.
Oh, loveys, we're just going to do it one time because we can't help ourselves. Oh, I found something in my pocket for you, good sir. Okay. Oh, flick it and lick it.
Rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you.
And that is it. These are real damages for real people who have suffered long enough. And I agree, loveys. And I think that also Karen Reed has suffered long enough. So with this, afterwards, they go into a scheduling, and the next scheduled hearing will be on Thursday, November 21st, 2025. We will be back in court. There was nothing ruled from the bench, just like who? Judge Beverly Cannoni, who is sometimes full of baloney. This was a lot. You all did beautiful. I sent a text to Mr. Betterow. What did I say to him? I said, oh, hi, Mr. Betterow. I said, Mr. Betterow, can I get a comment on Cosgrove? I am live. Blink twice and tell me. Ding dong, the case is over. He did not respond. Okay, so I'm going to take that as no comment. I also do want to say to you all that Mr. Betterow is coming for Sunday service this week. Where is he right now? He's over at Mikey's house, over at the Young Jerks. At 9:30 p.m. Eastern Standard Time, I am on for the last block of Court TV with Vinnie Politan tonight. If you would like to watch from like 9:30 to 10, or whenever you'd like to, that'd be great. If you don't want to, I hear that too. So look at me. I love your faces. Thank you for being with me 2 times in one day. No one asked for it. But thank you for showing up. I love your faces. Tomorrow, we're going to talk Kelsey. And if you are available, I would love to see you after work. Okay? Have a great night. Sleep tight. Don't let the bed bugs bite. Night night.
All right. Great job on the news.
Thank you.
We will, Courtney and I will share what happened when we went to dinner last night, Sunday dinner coming up. And as